Now to an update in a First Coast News investigation. Today, all parties involved in the St. Augustine surrogacy case appeared before a judge in St. Johns County.
It's a story we've been covering for weeks now. Kyla Simpson, the surrogate, is fighting for custody of the children she gave birth to after the intended parent, a man from China, didn't pick them up more than 20 months after their birth.
Investigative reporter Riley Phillips was at the hearing. She joins us in the studio now with more on what is next for this case.
It was a tense hearing with the intended parent's attorneys arguing he is the legal father and the California parentage order, which was signed after the babies were born, does apply in Florida. And for the first time, we're also hearing and seeing the intended parent.
Ms. Kaplan is a talented lawyer and is very good at distracting from the actual issue at hand.
Frustration in the courtroom Wednesday as Judge Rosemary Preddy hears from both sides of the surrogacy case. Kyla Simpson and her attorneys joined the hearing via Zoom along with the intended parent Chen Zhu.
Your Honor, I can give you money.
Judge Preddy wanted to discuss a number of specific concerns. First, she questioned why the intended parent's attorney did not tell her a Duval County judge dismissed the case just a few hours before they entered an emergency pickup order in St. Johns County to take the children from Simpson's custody on June 17th.
I don't know why that wasn't disclosed to me, even if he didn't rule. But I just wanted that clear because that would have been helpful.
Judge Preddy also wants to appoint a guardian ad litem, which is a neutral person who could act on behalf of the children during these court proceedings. The intended parents' attorneys, Kevin and Erica Healy, pushed back on this.
Fine, I am going to appoint a guardian ad litem in this case.
Your Honor, that's not set for issue today. And we've had no notice. We have plenty of argument to suggest that that's improper. There's no 39 proceeding. This is not a custody action between two parents. It's completely improper for that to be handled.
Sam Elliott, representing the Florida Attorney General's office, believes the California parentage order does not have jurisdiction in Florida since the children were not born in California and never lived there. The intended parent's attorney disagrees.
I have filed a brief with the court this morning outlining that the Attorney General's position was just facially deficient. That temporary injunction should be lifted immediately because of that. But more so than that, we have an abundance of law that would pertain to the subject matter jurisdiction of the California courts that entered the parentage order that would show that they did have the subject matter jurisdiction.
Another hearing has been scheduled for next week. During that hearing, the judge will hear arguments from the intended parent's attorney who want to dissolve the injunction that prevents the children from leaving the country, and the Attorney General's office will argue their motion for the judge to reconsider and cancel the child pickup order and potentially bring the children back to Florida.